Good morning, and brilliant to see such a great turnout on this subject. Before I get started, I just wanted to get a feel for who's in the room. So just sort of by a show of hands, how many of you are sort of working, would consider yourselves to be working in hospice and palliative care in some form? Okay, good split. How many of you within the NHS in that context? And what about local government? Yeah, brilliant. Excellent. A good mix of people, probably the right mix of people for what we need to be discussing. So a little, first of all, just by way of introduction about who Hospice UK is. We're the national voice of hospice care in the UK, supporting over 200 local hospices across the country in a variety of different ways, supporting their work, advocating on their behalf, and of course, raising awareness of hospice care. Some of the things that we do to try and achieve that, it's about championing the cause of hospice care, helping to improve the quality of care, not just within hospices, but actually for people at the end of life right across the board, offering education and training and practical support of a variety of different types. And there's lots more you can see on our website if you want to know more. But I think it's that sort of sets the context for why we're so pleased to be working with our friends from St Luke's and with our colleagues at the Law Commission on this event today, which is such an important opportunity for you all to input at this point in the development of a new framework for DOLS. So, what am I going to try and cover? I'm going to try and answer some of these sorts of questions. So, firstly, to look at actually defining some key terms. So for those of you, obviously, who are working in hospice and palliative care, these will be very familiar to you, but it's important that we have a sort of common understanding of what we're talking about. What's the issue? What's brought us to this point? Why does it matter? What does it mean for hospice and palliative care? What happens in practice currently? What's the experience that services and individuals working in those services have had up until this point? What's happened more recently? What are some of the recent developments? And finally, why is this event important? So hopefully, over the course of the next little period of time, we'll get through some of those. I'm not going to spend a huge amount of time on these. Obviously, the slides will be available to you afterwards, and you may want to refer back. But I think it is important because around palliative and end-of-life care, there are lots of different terms, often used interchangeably. And I think it's just helpful to remind ourselves really what we're talking about. So here you'll see, I won't read them out. You can scan through them yourselves. A couple of key definitions really of palliative care and end-of-life care. Those are two phrases that are very often used interchangeably, unhelpfully sometimes, particularly in policy documents. So it can be really confusing what we're talking about and who we're focusing on. Two more you'll see being used as distinct from end-of-life care. You'll see end-of-life being referred to often in different documents, and the popular definition of that is people who are approaching the end of life when they're considered to be likely to die within the next 12 months. And that's distinct from the end stage when someone is actively dying. Now, you see the overlap, the complexity of this is sometimes quite confusing, but it is quite important, and important to recognise, to focus on that the purpose of today's event is to think about how the proposed DOLS changes will impact in relation to people approaching the end of life. But starting off, why is it all important? I think sometimes the temptation is to look at the process, to look at the system, and to look at why it's not working or how it needs to work better. But actually, it's useful just to remind ourselves where this all came from, and what it's set up to do, what it's seeking to do. The deprivation of liberty safeguards obviously were introduced in April 2009 as part of the Mental Capacity Act to fulfill a very important function, which is to protect the right of people who lack capacity not to be unlawfully deprived of their liberty. So it's an absolutely critical protection for some of the most vulnerable people in our society and in our care system. The principle, of course, is critical in all settings, but I think that there's a particular challenge, particular resonance for people at the end of life which is a particularly, especially vulnerable stage of life. And we'll come on to that in a little bit more detail in a few minutes. Many of you will be familiar with this, but I think this just illustrates the scale, why this resonates, why it's so important for people at the end of life. So of around 500,000 people who die each year in England and Wales, 78% will die in some form of formal care setting, whether that's hospital, a care home, or a hospice inpatient unit, and around 22% dying at home. So around 78% of that 500,000 people are potentially within this, within the scope of this, the need for this form of protection for their rights. How did we get here? This might be a little bit tricky to read, but this is just a sort of pen picture, really, an outline of what's happened over the last sort of year or 18 months that have brought us to this point. In policy terms, this has actually moved incredibly quickly, unusually quickly, over the last few months, over the last year or so. The sort of most critical point, really, at the top of this tree, really, it was the Supreme Court ruling back in March 2014, which broadened the scope, in practice, of DOLS, came alongside a very critical report of the implementation of the Mental Capacity Act and DOLS by the House of Lords. Led, of course, to a government response, as you would expect, and the government asked the Law Commission to review the legislation. It started off being quite a narrow request, which was then broadened in scope. Earlier this year, and you'll hear more about this later, I'm sure, Department of Health issued a letter to services updating on some of the developments. The Law Society published some guidance, and I'll refer to a couple of those in a little while. And then more particularly recently, the responsible minister for the Department of Health, Ellis, announced that the timetable for the new draft legislation will be brought forward from 2017 to 2016, which of course ties in extremely well with the main reason we're here today, which is to look at and consider some of the ideas, some of the proposals that the Law Commission will be making. It's also important, I think, to look at this within the broader policy context. This isn't an issue that's taking place or challenging us in isolation, and it really is part of a much bigger agenda around choice, control in end-of-life care, which is very much a key concept and a key priority, a welcome priority actually for governments over the last few years. Of course, very closely linked to the encouragement, the support, the promotion for advanced care planning, which is encouraging us all to think more and express our wishes and preferences as we approach the end of life. It also relates, I think, very directly to the challenge that's been set to the health and care system around the identification of people approaching the end of life and how the system, in its broadest sense, can be better prepared to meet people's needs. Breaking down the taboo around death and dying and bereavement, very much part of the Dying Matters agenda that I'm sure many of you are familiar with. And then more recently, a very important link to the Prime Minister's Dementia Challenge, which is really sort of set a challenge to the whole system for how we're going to become a better prepared system for meeting the challenge of dementia into the future. So DOLS isn't happening in isolation. These discussions aren't happening in isolation, and I do think it's helpful to see it as part of that broader direction of travel, which is about how we make services more personalised, more responsive, more integrated for people, particularly approaching the end of life. So the focus today isn't to look back at where we've come from, but is to look forward about where we might be going to. Having said that, I am going to spend a few minutes just looking at some of the challenges that the current system has presented for hospice and palliative care, and I want to get you all thinking as well in a few minutes as well. So what are some of the issues that we've heard from our member hospices about how this is impacting on them? And I've just pulled out half a dozen different issues here. The first, in no particular order, I should say, the first issue really is around the inconsistent interpretation of what constitutes a deprivation of liberty, particularly within the context of hospice and palliative care. And I'm sure that's something that many of you have experienced, that it seems to work in different ways, different areas, different individuals, and of course that creates some confusion, some uncertainty, and some anxiety actually for practitioners on the front line, and of course for families too. The process of applying for a standard authorization, well, when the average length of stay in a hospice inpatient bed, and obviously hospice inpatient care is only one part of what hospices do, but the average length of stay in a hospice bed is 13 days. But of course, the process for applying for a standard authorization far exceeds the average length of stay in that hospice bed, so that creates a very practical challenge. But at the other end of the scale, instead using an urgent authorization, which obviously only lasts for 7 days, are not going to be suitable where a person may be in a hospice bed for less than 7 days. So there's a set of challenges around whether the system currently is fit for purpose for the needs and the care that people receive, particularly in a hospice setting, but actually generally at the end of life. People access hospice care from a variety of different settings. So the issue here is particularly that, of course, a DOLS application is setting specific. So particularly where people may be being transferred to a hospice bed from a hospital, for example, it requires a new application to be made, ideally before the transfer. So it creates another set of challenges around timescale and process. So that may be something we want to pick up later in the day. But perhaps almost most importantly is the potential for distress to families. And as Chris said in his opening remarks, the death of a person subject to a DOLS authorization is classed as a death in state detention, which should be subject to a coroner's investigation. And that can create enormous distress and worry and anxiety for families at what is already an incredibly difficult time for them. These are some of the comments that we've received over the last few months from local hospices around the country, really just to emphasize and illustrate some of those experiences. So you'll see here the comments that different hospices are interpreting the legislation in different ways. Some hospices making a significant number of DOLS applications, so that issue of consistency. The best interest assessor had indicated that further guidance with relation to DOLS and end-of-life care patients was required. So this is, from a frontline perspective, this is what the system is then saying to practitioners. Families don't understand why what they see as an expected death is a death in detention and needs to involve the coroner. So that's about a perception issue and the impact on families and the impact, of course, on their bereavement. Bottom right, you'll see the comment there about the timescales, the timetables for urgent referrals, urgent assessments. But top right here, you'll see some of the sort of ways that different hospices, just an example of some of the ways that different hospices have tried to make the best of the situation as it currently stands. So this hospice saying that actually they've created a folder of resources, including easy read information for patients' families, to help support the discussion around best interests. So there are lots of examples like this of at a local level, at an individual service level, trying to make the best of the situation as it currently stands. So a few sort of broader contextual points around capacity, mobility, and end-of-life care, which for those of you, again, working in palliative care, this will all be very familiar to you, but I think really illustrates the importance of this issue in the context of end-of-life care. So the first point being that everybody loses capacity at some stage towards the end of their life. So in effect, we're talking about everyone who's dying, potentially, and making sure that we've got the system right and the protections right, going back to that initial point, that this is about protecting people's rights, that we get it right for people. Some people require constant supervision and restrictive practices. So, for example, people with dementia or some forms of cancer who can be quite mobile while lacking capacity. So that whole question around restriction becomes very important. Other people can be rendered immobile as a result of their condition, which will require constant monitoring or a high level of monitoring and supervision. And others, of course, can be rendered immobile by their care rather than their condition, for example, as a consequence of their medication, which again will require a high level of monitoring and supervision. So you start to see that actually the potential scope here is enormous for people at the end of life. So to illustrate, just to emphasize the variation, I've got a couple of examples that I want to share with you, and I want you to do a little bit of thinking just with the people next to you about what you think might have happened, what you would have expected to see happening. And here's the first example. These are real life examples, I should say. We had a patient transferred from our local hospital who had cancer, had suffered a stroke. He was not responding, understanding when he was admitted, but he didn't appear to be in the last days of life. An urgent application and a standard application for doles was made. He had no family or next of kin. So just amongst yourselves, just for a couple of minutes, just what would you expect from your experience? What would you expect to see happen, or what would you assume might happen in that sort of context? I'm loath to stop those sorts of conversations. This isn't a test. We're not going to ask you for any input, etc. But I just want to then give you what actually did happen in this case. So the assessor came to see him from the local authority, who seemed completely at a loss as to why she was here and what she was supposed to do. He then died a couple of days later. I didn't refer his death to the coroner, as I'd had a verbal confirmation that they were not wanting us to, but I'm waiting for that in writing. Now, I suspect that's an experience that resonates on some level with some of you. I've got another one. So here we go. So here's example 2. A patient with confusion and potential terminal agitation required one-to-one supervision to maintain safety. A mental capacity assessment was completed, and the patient lacked capacity to make a decision about their care. An application for authorization of doles was made to the local authority, and CQC were notified. So again, a couple of minutes. What would you expect? And what's your experience around this sort of context? Again, brilliant energy in the room. It's fantastic. Resonate as a sort of example. Okay, this is what happened. So over the next few days, the patient became less well and was dying. A mental capacity assessor visited the patient and confirmed that she lacked capacity. The best interest assessor contacted the hospice, and after discussion and an update on the patient's condition, as she was semi-conscious and no longer required continuous one-to-one supervision, a decision was made that it would be intrusive and inappropriate at this stage for the assessor to visit, but that I'd keep the assessor updated. The patient died peacefully 2 days later. So I think the message that I hope this is given and that you will be aware of from your own experience and practice is that actually I think one of the central challenges, the key challenges, is lack of clarity moving forward. And that's something that I think that the consultation that we'll be hearing more about later on and that you're all here today to feed into is so important, that we've got this brilliant opportunity now to try and input and develop and help build a system that is clearer, that is more consistent, and that continues to serve the core objective, which is about protecting people's rights. I don't know whether many of you have had a look at this, but this is an extract from the Law Society guidance earlier this year that provided, I think, quite a helpful insight into the factors that are likely to be taken into account when considering whether a deprivation of liberty is taking place. And you'll see there that I think there are sort of a number of different sort of factors that it's worth bearing in mind. The first really being about the changing circumstance that someone may find themselves in at the end of life. And of course, for people approaching the end of life, changing circumstance is extremely common, extremely likely. There's an issue around, in the second bullet point 2 and 3 there, around the use of drugs, the use of sedatives in particular, as being important factors to bear in mind. So the first bullet point there, as I mentioned, that it says that the circumstances are no longer covered by a consent given on admission. So that's about the change in circumstance. The second bullet point there is administering sedatives to decrease anxiety or agitation, and the third around chemical restraint. So that's around the use of drugs and sedatives in particular. The fourth, constant supervision in care of terminal agitation. So that supervision point, which actually came through in some of those examples that I just gave, is obviously a really important factor. Restrictions on movement then, as the final point. So it says restricting movement on patients who are mobile so that they're not free to leave the hospice grounds because they may be a danger to themselves. So that's about restrictions and that balance that all of you will be trying to strike in your practice every day around freedom and restriction, particularly for patient safety. Final slide, or penultimate slide really, is just to remind us, so that was a bit of looking back at where we are, where we've come from, where we are currently in terms of the experience. But importantly, the focus today is about looking forward and the opportunity to feed into the Law Commission consultations, which will be proposing, and you'll hear lots more about this later on, proposing recommendations to the government on how the law could be updated, the law underpinning DOLS could be updated to better serve the needs as they currently are. The consultation runs until the 2nd of November, so there's a good opportunity. You're actually very early in the process. You're having an early say, early input to some of this thinking. And our thinking as a group of organisations was the value of bringing all of you as the experts on the front line, the people working on the front line, whether it's in hospice or palliative care, whether it's in the NHS or whether it's in local government, the experts who can really feed into this really important consultation and have your say in how the system could work in the future.